recording. I'm going to start. Hi, Adam, by the way.
Hi, how are we doing today?
Good.
Yeah,
Hi, Adam. Good to see you.
I don't know why my name's popping up as Steve's. It's
A
weird.
lot worse.
Good.
if he's paying the bill, you'll let him put whatever name he wants.
All right.
Hi, everybody. Welcome. As people are coming in, we're going to give it just a minute and we're going to get started. Thank you for taking the time to be here today to hear about this important topic. Todd, if you want to start the slide so people can see. We're already at the 25, so good. Good to see everybody today. Thanks for being here. You want to share the next slide for me? I just wanted to thank our diamond sponsors for the year. Without their support, we wouldn't be able to do what we do. So we wanted to thank them. We do that at the start of every webinar. And then I'm going to hand it off to the experts here. We have Todd and Elia and Adam and Steve, our lobbyists, all on today to tell you what's happening with the chicken bill. So thanks for being on. If you guys aren't able to stay the whole time, we are recording. So I will send a recording when we're done.
You throwing it to me?
Sure, yeah. Elia, go ahead.
That was a long pause there. Hi, everybody, and thanks for being with us. Thanks for taking some time out of your busy days. Really appreciate it. For those who don't know, my name is Elia Ellis, and I am the chairman of the Missouri Legislative Action Committee. And we have somewhat of a unique situation this year where some unfortunate legislation, commonly known as the chicken bill, has been passed into law and recently signed by Governor Parsons. And we believe that it is a situation worth fighting, as is going to be explained to you in just a couple of minutes. There is a basis to fight the chicken bill before it becomes law on August 28th by filing a lawsuit. I'm going to let our lobbyist, Steve Carroll, speak to you now to explain how we got here from the beginning of the legislative session to the present time, and the basis upon which we can fight it. And then Todd Billy's going to speak some more, and then I will speak back again at the end. So take it away, Steve Carroll.
Thank you, Lib. I am Steve Carroll. I am president of Carroll and Associates, a government relations, lobbying, and law firm. We're happy to represent CAI in their actions before the legislature. Before I started my firm, I was a member of the Missouri House of Representatives for 10 years. And so I think I know the legislative process fairly well. It all basically started when House Bill 2062 was introduced in the House, which was a simple one-page bill, 2 sentences that put a moratorium on evictions. And it all came about because of the COVID crisis, and some of the cities in the state were putting moratoriums on evictions for people. And so the state decided that the state should oversee that, not local control. That bill passed cleanly out of the House, just as it was. But once it got over into the Senate, there were some senators that wanted to change basically the title of the bill and change the title of the bill to the use of real property. And on the day of Tuesday, May 7th, on the Senate floor, a Senate substitute for this House Bill 2062 was presented. And numerous Senate amendments were drafted and put into a new floor Senate substitute. And unfortunately, one of those amendments was the so-called chicken bill that does away with the HOA's ability to not allow chickens in yards up to 6 chickens in 2/10 of an acre. And so the bill and that amendment were passed when there were very few senators on the floor that day. There was no actual vote taken other than an A or nay, a voice vote. I think we were sitting there when it happened. There were 4 or 5 senators in the entire chamber. Most of them didn't even know what was taking place on this bill. And so numerous amendments dealing with things other than the moratorium on evictions were put on this bill in the Senate, dealing with electric vehicle charging infrastructure, restrictions, land bank agencies, public sewer district liens. They started a new act called the Historic Rural Revitalization and Regulatory Streamline Act. They put an amendment dealing with home inspections, one with squatters removal from residences. They even did one with fire hydrant testing. So none of these really have to do anything with the original bill. And at the end of it, you had a 75-page omnibus bill dealing with various subject matters. Now, the reason that we feel like we can file a lawsuit is based upon the 1994 Supreme Court decision called the Hammersmith versus Boone County. And it came down that Bob Hammersmith in Boone County filed a lawsuit against Boone County for an issue that they were trying to adopt. It all came about because when I was in the legislature in 1993, there was a bill that passed dealing with elections and dealing with voting. And the bills were combined and passed, and the governor signed it. Well, it violated the Missouri Constitution. And under the Missouri Constitution, in Article 3, Section 21, the Constitution prohibits bills containing more than one subject, and no bill shall be amended in its passage through either house as to change its original purpose. And then also in Article 3, Section 23 of the Constitution states, no bill shall contain more than one subject, which shall be clearly expressed in its title. That provision has been in the Missouri Constitution some way in every constitution since 1865. And so the Supreme Court ruled in favor of Bob Hammersmith that those bills violated the one subject rule. Now, I can tell you this bill 2062 should be the poster child for why Hammersmith is there and based upon the Constitution. And in a decision that was rendered down in 1962, even before Hammersmith, it stated, the court stated, the third constitutional provision serves to defeat surprise within the legislative process. It prohibits a clever legislator from taking advantage of his or her unsuspecting colleagues by inserting unrelated amendments into the body of a pending bill. And that's clearly what has happened here. We have had discussions with Chuck Hadfield, who is an attorney in Jefferson City. He was the chief of staff to Jay Nixon for all the years that Jay Nixon was in the Attorney General's office. And so Chuck Hadfield has had a lot of experience dealing with government, the Hammersmith issues. And so we have talked, and he has indicated without a doubt, in his opinion, this is a clear violation of all the different amendments going on to an original bill that basically had nothing to do with HOAs and chickens. Now, there's never a guarantee in any lawsuit that you're going to win, but I certainly feel pretty confident based upon other Supreme Court decisions that this is a clear violation. And so that's why we have been in discussions with Chuck Hadfield. He said he's more than happy to take this issue on, as he believes it's a strong case as well. So just a little background on the legislation, how it comes about. It's very hard to lobby against something by surprise. In the House of Representatives, for instance, when a bill comes to the floor, if there's going to be an amendment offered, they have to put that amendment in writing beforehand so you can see several days in advance what's coming before that bill is brought up. In the Senate, you don't have to have that. They can write an amendment while the bill's being debated. They can write an amendment while they're sitting at their desk on the floor of the Senate and turn it in. So it's very hard to lobby against that. We were able to stop the bill, the chicken provision of the bill, in the House, but we weren't able to do it in the Senate based upon you have a House member who has a couple grandchildren that want to have chickens as pets. And obviously their HOA doesn't allow that. And so he's tried for years to try to get this passed in the House and has not been able to. But his son works for a senator. And so the senator offered the amendment on this bill on that Tuesday afternoon. So that's just a little of the background for you. But certainly, having been involved in the legislative process for 40 years and having been a member of the legislature when the Hammersmith decision was handed down, I feel we have a pretty strong case. So with that, Eli, I'll turn it back over to you, or if there's any further things you'd like for me to discuss on it, I will.
Thank you, Steve. For the moment, that's good. I'd like to next pass the microphone to Todd Billy to talk about why this fight is important to CAI and to the Heartland chapter specifically, and the reasons that we ought to gear up to fight this, because as you might suspect, at the end of this call, we're going to ask for some donations to a litigation war chest. Spoiler alert. But I'd like for Todd to sort of emphasize what are some of the main reasons why this should be important to all of us.
Yeah, thanks, Lion, and thank you, Steve. Just to show, I won't say how long ago it was, but I first met Steve in Jeff City when I was there interning in college. So he absolutely does know the legislative process, knows how it works, and I was not happy when I received this text very late on that Tuesday as to what was going on with the Senate. So Steve is looking very reserved right now. He was not on those texts. So he's passionate about us more than it might seem for what you're hearing today. So he does care very much, obviously, so do we. So it really comes to, the way I look at this issue, which is very similar to the political science is, political science at least had a constitutional component to it, speech and elections. Well, here what we have is, you have the real estate signs, the solar panels, now we have chickens. The legislature has clearly said, we really don't care about what HOAs are telling us, even when we reach out and, we do the alerts and emails go to legislators. If they can get what they want without the industry responding, it's not only chickens. Representative West over the years has filed a different number of bills. And a lot of his legislation dealt more with management companies than individual HOAs. So when you have this HOA and we all get roped in together, the General Assembly is going to be more aggressive on these topics that would otherwise be in our control. So I look at the first one is really it's a matter of, if we don't fight, they know we are nothing more than complainers. And that doesn't really help. We can show there, we can talk about it being important, but it's a little bit of put up and shut up when it comes to how much you really dedicated to the issues that you're presenting. Now, the other one, which I think is where the kind of the money ask comes from is, some stations do allow chickens, and that's fine. But those that don't, or recognize the inherent cost of implementation of this statute, as the statute reads, we can do reasonable rules. Okay, well, what does that mean? So we could still be fighting over chicken coops that we'd have to allow. So the other one is, do we have control over this topic ourselves? And that, to me, is the more important part for HOAs is, this isn't a political speech issue. This is an issue that is clearly within the wheelhouse of what the owner should decide for themselves. So I look at those as the big reasons why, and yes, I will be contributing money as well. That's why I think it's so important for us as an industry to fight. Elia, you want me to kick it? Is it going back to you? Is there a certain slide you want me to jump to?
No, I'll talk a little bit about the ask now. So as Steve mentioned, we've spoken with Chuck Hatfield, the attorney in Jeff City, who's extremely experienced and knowledgeable in these matters, who likes our case, who's willing to take it on. He has quoted us a flat fee, which would be less than his regular fee to handle a case like this. He has indicated to us last week that he would handle it for a flat fee of $50,000, which would include everything through and including the appeal of this case, which we expect will occur. It's likely that at the trial level, the case will go actually very quickly because there won't be a need for discovery, and the case can probably be submitted to the judge on briefs and arguments without an actual trial. But that once, and even if we win, this is, I don't know if Steve mentioned this before, this case will be defended by the Attorney General's office. It's their job to do that, to represent the state. And they will, even if they lose, they will appeal the case. And the appeal, as I understand it, will go straight to the Supreme Court rather than to the Court of Appeals. And so Chuck's quoted fee of the $50,000 will include his time on the appeal, which he thinks is really where the main important argument will ultimately play out. So we have a target of $50,000 that we want to raise. This is not something, as you can imagine, that we had planned for or budgeted for in our regular annual MOLAC budget because we didn't foresee this coming. And I'm very pleased to announce that we made an application to CAI National's Legislative Advocacy Committee, and they have a little bit of a fund, and they have agreed to contribute $10,000 as a grant to this litigation effort towards the fees. So that's extremely generous. And they were very enthusiastic and felt very strongly about this issue and about us putting up a fight against it, which is why they approved the money. So we're looking to raise another $40,000. And we're going to be asking not only of the management companies represented here today, but of all of our chapter business partners and the homeowners associations individually. And we're going to be asking the management companies to help us to communicate by and through and with your various association clients in order to either get $1 a door or some other sort of contribution towards this special fund, which is above and beyond our regular annual needs for the MOLAC to take care of its business. And so we're asking each management company who's capable to contribute a minimum of $1,500, $1,500. I know it's a big ask, but this is very important. It's something that does not come around very often. And we feel like it's very important to be able to put up a fight here. And especially because we like our chances of winning here, to be able to show not only the legislator, but also some of our other sort of opponents in advocacy at the legislative level that we're a serious force to be reckoned with, and that the sanctity of our HOAs and their governing documents can't be taken for granted and can't be trumped by state legislation. So that's the ask, is for $1,500 or more if you're able per management company. And if you are able to, as you can see on the screen, the best way to do that will be to send a check to MOLAC at the PO box on the screen, or you can also use the QR code that's on the screen as well. And having said that, Steve or Todd, if you think there's anything we've forgotten, let's add that now. Otherwise, we can open up to if there's any questions from our audience.
No, I think you all hit all the high points pretty well, at least from my standpoint. I'd be happy to answer any questions.
Yeah, I'll just chime in a little bit just in terms of the flat fee. We were able to, in-house, we were just wondering whether or not it would be competitive when we heard some of the first larger numbers, just to see what the viability is, for what we might think of as a competitive bid. The flat fee at 50 is a very good deal. Just so in case you're wondering, that seems like a lot of money. When we priced it out, we were higher. And that was already doing the deal on our end, what we could have it make sense. So it is a good deal.
No, and I'll chime in on that. I've known Chuck Hatfield for decades, and he is one of the most well-respected attorneys in the state, certainly in Jeff City and government circles. And he pulled me aside after our first meeting. He said, Steve, he said, I'll do this for a lot less just because I think it's just a great case to take and I'd love to take it on. And he said, I can see that you're all passionate about it. He said, let me tell you, he said, eviction moratorium on evictions and chickens have nothing in common. He said, I think this would be a fun case. Not to mention the 50,000 flat fee. It could, in fact, be less should the AG, probably not going to happen, but should the AG, if we win on this court level, decide not to take it to the Supreme Court, because a clean bill of the moratorium eviction has already been passed and also signed by the governor. So there is a possibility that that it could not be appealed. Doubtful, but because there's one provision with the land grant banks that the independent bankers would really like to see that become law, which is part of this omnibus bill. So we'll see how it goes, but I think Chuck is doing us a great favor by taking this on as flat fee. I agree with Todd.
The last thing I wanted to add, in addition to how to donate, is when to donate. And as I mentioned before, the bill becomes law on August 28th. And Chuck Hadfield has indicated that it is very wise to file the suit before it becomes law. And he feels like he can put together the lawsuit and get it filed, and if need be, file for a restraining order in terms of the state enforcing the legislation or it becoming effective law if we file the suit before August 28th, and he can get his lawsuit ready and filed once we give him the go-ahead. So therefore, the ask would be, when you're able to make this donation, to do it within the next 7 to 10 days so that we can make sure we've got critical mass for our war chest and we know that we can go forward with it financially with confidence. So we're asking people to do it and do it right away. With that, I'll open up to any questions that anybody in the audience may have. Kathy, would we be able to hear them if they have questions or?
Yeah, so I see one. What would happen if we win the lawsuit, then put something together that a HOA can regulate the chickens? Then the homeowners tell the HOA board that they need these chickens as an emotional support animal. In this case, the HOA would have no choice but to allow the owner to have chickens.
I'll jump in. It's a little bit conclusory that just because they say they're emotional support animals, they can have chickens. So forget the bill. That's still there. So essentially, by fighting this legislation, we're keeping the status quo. Department of HUD has a rule out that if you have emotional support animals, dogs, cats, the more typical domesticated pets that we think of, it's a lower standard. If someone wants to assert they have an emotional support chicken, they have to satisfy a different standard of care before it counts as discriminatory. But it's case by case. So that association should work with its legal counsel, but it's not, hey, they're there for my emotional support, I get the chickens. It's not quite that way. It's not that easy.
Patrick said, thanks, sounds good.
I think Patrick really just wants the chickens. I think he needs some emotional support.
Yeah, I see a question from Adam Jennings about whether this affects condominiums, and the answer is it does not. The bill is specifically targeted at HOAs and specifically excludes being applicable to condominiums. So this does not at all apply to condominiums in Missouri.
Yeah, the issue is take out the condos. Single family, at least you have lots, right? That's at least you know where the lines are. townhome villa, it's gonna get ugly. Gonna get ugly pretty quick.
We have one more. Are we looking to modify the bill or have it removed altogether?
Well, on a Hammersmith issue, if the judge rules that just the portions of chickens should not be in the bill, they can do that. Or they can just throw out the entire bill because I would think they would throw out the entire bill because not one of the amendments that were offered has anything to do with the original title of moratorium evictions on evictions. So I would anticipate that if the ruling is in our favor, it would go ahead and take out the entire bill.
The case law, I think the test is something like they can sever the bill. In other words, they can cut it back up if the court knows with certainty that the bill would have otherwise passed without that. And it seems like in the case law that I was looking at that the default tends to look like we don't know, and since we don't know, the default is the whole thing goes.
Got a couple more.
I know there was in the Q&A, there was a question on municipalities.
Yeah.
Generally speaking, this bill is specific to HOAs. So for a city, obviously city or other political subdivision needs to talk to their attorney as to its implications. But generally speaking, if a city has been leaving it to the HOAs and they've been happy with how that's been working, well, now the city might have to be more proactive in their zoning. And then it comes down to enforceability, which they think of it's like parking. Some associations like, well, we'll just leave it to the city. And then if the city is inherently just being a little bit lax on parking, then the HOA gets upset about it. Well, you gave up that authority because you reverted to the city enforcing it. So cities will have to enforce ordinances.
Yeah, I see where Eric submitted a question about the timing. If a HOA board adopts a resolution with chicken coop guidelines, I assume he's meaning pursuant to the provision in the chicken bill that allows the boards to adopt reasonable rules, and whether those would be effective immediately or they have to be a waiting period. And I would say that would be dependent simply on the association's governing documents and whether a waiting period is required or notice to the owners prior or whatever specific to that HOA.
Yeah, I would agree.
Yeah.
Adam, do you have anything you want to add since you're on?
No, that sounds good. I see there was another follow-up with the state law being overriding county municipal laws. The bill that was passed specifically deals with HOAs. It says HOAs can't restrict this. So county municipal laws are still in effect. If the bill said residents of Missouri are allowed to have 6 chickens, then that would override county municipal ordinances. But since it's strictly dealing with what HOAs can and can't do, it does not mention municipal ordinances that would remain in effect with this bill. So I hope that helps clarify that issue.
Yeah, I think that's right.
Thanks.
Okay. MOLAC is putting together a communication piece that the property management companies and their managers can use in talking with their client boards about this issue specifically, and the secondary ask that we're going to be making of HOAs individually to contribute to this litigation effort. Today, we're focusing on addressing you, the management companies, and asking you to contribute a minimum of $1,500 if you can or more. And I really appreciate everybody taking the time to listen to this today, to asking your questions. And I hope that you all be sufficiently motivated to remit your payments right away, again, within the next 7 to 10 days, so that we know we have enough of a consensus financially to go ahead and retain Chuck Hatfield and get going, giving him enough time to get his suit on file and do what he needs to do before the August 28th effective date of the law. So thank you all very much. I appreciate your time. And Kathy, I think we're ready to conclude.
Yeah, just wanted to remind everybody about, we got the trade shows coming up. We will have a MOLEC booth at the trade shows where we will also be asking for donations and having the QR code, so it should be easy for people to donate if they want to. And we'll be taking like donations then if they want to donate. We'll also be following up with the recording of this video so you guys can share it with those that weren't able to attend. And we'll also be sharing some more like documents and like a one-pager for you to share with your clients. If you guys have any questions, feel free to reach out to us. We appreciate you. Thank you for taking the time to do this, especially on this short notice. We really appreciate it. Hope you guys have a great day.
Thank you, everybody.
Thank you.
Thanks, everybody.
you.
Thank you for being here.
Appreciate it.
Bye.